We've made a promise in our 2019 manifesto to lower overall numbers, and I think it's good for the economy in our country, and actually, politically speaking, it would be good for our party as well if we can go back to the electorate and say we've lowered overall migration. I was a lone voice in that argument.
Hello and welcome to Spectator TV. I'm Gus Carter, the Spectator's Deputy Features Editor, and today I'm joined by Suella Braverman, the former Home Secretary who served under Liz Truss and Rishi Sunak, and before that was the Attorney General. Throughout her career, she has been a vocal Eurosceptic and a voice for the Tory right. Following the Conservative Party's defeat at the general election, she wrote in The Telegraph that the party failed in office and deserved this result. Suella, thank you for joining us. I want to start by talking about that failure in office, and particularly about the Conservatives' record on immigration. When the Conservatives first won in 2010, David Cameron said he wanted to get net migration down to the tens of thousands. Under your stint in the Home Office in 2022, I think it was, net migration hit the highest ever on record, 745,000. Can you tell us why that happened?
Yes, Conservative government failure is the shorthand answer. But the reality is that pledges were made. You named David Cameron when he was Prime Minister, but Boris Johnson and Rishi Sunak and all Conservative manifestos really since 2010 all promised to cut overall migration, and we all collectively failed to achieve that goal. Why? Post-Brexit, we took back control of our borders. We designed a new points-based system, which swept away the old Brussels diktat on free movement of people. And the expectation was that we would exercise our new levers on legal migration in a way that would reduce overall migration. What turned out was we did the exact opposite. And so when I arrived in the Home Office in the autumn of 2022, I was horrified by the previous set of data that had been published in the July of 2022, setting out that we had issued a record number of work and study visas. They topped the million mark for the first time. I went in 2022 determined to honour our manifesto pledge to cut overall numbers, and the figures that you just referred to were published in that November. What I managed to do was get a few changes to how we take in international students and dependents, and we did ultimately see a beginning of a turning of the tide and the numbers to start falling with most recent data. However, that's by no means an excuse. We overall failed to lower numbers on migration because we didn't use the levers that we had available after Brexit.
But why didn't you use those levers?
We didn't use those levers because the political support and the political appetite wasn't there around the cabinet table. The prevailing orthodoxy on immigration was that more immigrants coming into the country would be a good thing for the economy. I was often told, despite my best efforts and frustrations, that if we were going to cut the number of work visas or reduce the number of students, that would have a net negative effect on revenue, and that would be bad for growth and it would be bad for the economy. I disagreed with that view fundamentally because I don't think I think there are long-term costs actually associated with the levels of low-skilled, low-wage migration that we've taken in recent years. But that's not a calculation that the OBR takes into account.
No.
Historically, the OBR has been in favour of higher migration. We're seeing a bit of an attenuation of that view in recent months. But for years, in my experience of the OBR, the Treasury, the Department for Business, the Education Department, the Health Department, all sorts of departments that have an interest in migration were all heavily in favour of more migration. And the Home Office was the lone department arguing, kind of in the wind for us to cut the numbers.
So you said earlier this year that Rishi Sunak blocked you from kind of trying to bring down those numbers. Why is it that in public he was saying, we need to get the number lower, and then in private he was saying, actually, we need this, for the bottom line, for the country's finances.
You'd have to ask him. I wasn't responsible for his
but I mean,
messaging
you must have asked him.
his.
You must have asked him. Why are we telling the public one thing and then doing something different in private?
Well, I mean, I have set out my frustrations quite a lot about why I was blocked on lowering legal migration, and not wanting to rerun the story again, but I actually couldn't get a meeting with the Prime Minister for over a year to talk about cutting legal migration. I was left to writing letters on several occasions, and it wasn't seen as a priority. And I think if I'm looking at the political context, stopping the boats was seen as the top priority for number 10, the Prime Minister, and a lot of political capital was being expended on stopping the boats. And legal migration wasn't really seen as a necessary or urgent matter for the Conservative government to deal with. I disagreed with that view. I said, repeatedly, we've just had Brexit, which is a very strong call from the British people to lower migration. We've made a promise in our 2019 manifesto to lower overall numbers, and I think it's good for the economy in our country, and actually, politically speaking, it would be good for our party as well if we can go back to the electorate and say we've lowered overall migration. I was a lone voice in that argument.
So part of the system when it comes to legal migration is that companies or organisations apply for licences to be able to, bring in workers on worker visas. I think the number of licences that have been handed out have something like tripled since 2020. And actually, one of the things I found interesting is recently there's been a big uptick in kind of revocation of licences, partly because there are concerns around whether or not a lot of these are kind of legitimate, kind of especially within the care sector. I wonder whether you saw kind of any evidence of those concerns while you were in the Home Office.
Oh, absolutely. I mean, not just when I was in the Home Office, but when I was Attorney General, I saw it. And even before I was an MP, I was a barrister for a decade, and part of my time as a barrister was spent defending the Home Office in immigration cases. You talked about visiting the First Tier Tribunal, and I didn't quite do First Tier Tribunal work, but I did Upper Tribunal work and High Court work, and very often I saw cases which I really strongly suspected were fraudulent. There was an element of fraud in them. But when I was Home Secretary, and thanks to a lot of investigative work by journalists, actually, but also reports that we would get from our caseworkers, I became aware of real abuse of the system. So in many forms. So you would get immigration practitioners, purporting to be qualified, purporting to be regulated, but actually being fraudsters and aiding and abetting fraudulent claimants in immigration claims. There's people making up claims, so fabricating their Christianity. I became aware of churches that were effectively kind of rubber stamping, migrants and saying, well, yeah, we think you've now converted to Christianity, we'll give you a baptism certificate, and it doesn't matter if you don't attend Mass, doesn't matter if we don't really know you, but we'll say you're a Christian, and then you can make that part of your legal claim to the Home Office and say, well, you're a Christian, so if you get returned back to your kind of Muslim country, you'll be persecuted because you're a Christian. That's almost a surefire way of getting a grant of asylum in your favour.
Was the Home Office having discussions with the Church of England about stuff like this and other churches?
So I convened, a task force. I put together a new task force to deal with this issue with the regulators, with immigration enforcement, which was our arm in the Home Office, dealing with investigations and prosecutions for precisely this kind of abuse. And as a result, we did increase the number of investigations and the number of prosecutions. It's very slow work. It's very hard to see results quickly. And ultimately, I very much hope that work continues right now, because there's a real and clear need for it.
So just going back to the Tory leadership election, one of the big issues was the ECHR. And that's something that you think we should leave. You've been very clear about that. One of the things that I found, you mentioned a piece I wrote a couple of weeks ago, is that when you look at the statistics, there are hundreds of thousands of people here who have applied for asylum, who have been rejected by the Home Office, and yet they're still here. I think only something like 10% of people who have been rejected by the Home Office have been returned. Why has that happened? Because it's dropped off massively. I think in 2013 it was something like 62% of people who failed in their asylum claims were returned. What's happened?
in a few words, barriers to removal. So what happens, and I studied this issue in depth as Home Secretary, and we actually did increase the number of removals while I was there, but still by no means enough. When the way the process goes is, say someone's overstayed their visa, so they're here illegally, or say they've come here illegally in the first place, so they have no basis to stay here, and the Home Office deems that they should be removed. We'll start the process of issuing the various notices to potentially detain them and then remove them. The minute we do that, we'll get hit with legal claims by the person in question, the claimant. And they will have an army of lawyers, publicly funded, by the way, who will put in legal claims, i.e. barriers to removal. Now, those claims are made up of a plethora of kind of bases. Human rights claims are very, very common. They'll claim to be a refugee, so in fear of persecution if they go back to their country. Modern slavery. A very big example of unintended consequences. That started off as a piece of legislation that the Conservative government introduced because we were being compassionate and wanted to protect victims of modern slavery. It's now become a charter for illegal migrants. Pretty much or a large number of illegal migrants will claim modern slavery. And the minute they claim modern slavery, that triggers an investigation and various levels of provision of support from the state, and they can appeal these decisions if they're refused, and they can appeal, they can judicially review, they can ask for a reconsideration, and there's a whole marketplace of legal claims and a whole industry set up to enable people to put in legal claims and thereby delay and ultimately prevent their removal from the territory. And we're not alone in dealing with that.
No.
France only deports about 10% of the people it seems it wants to remove from its territory. Italy, only about 20% of the people that they want to remove actually get deported. This is a challenge faced by many countries.
Well, this is one of the things I wanted to ask you about, because I think it almost seems like wanting to leave the ECHR is jumping the gun. There are now kind of, all the major European countries recognise this issue. Would it not make more sense to go to the other signatories and say, let's renegotiate this, let's set up a new convention for the 21st century rather than leaving the ECHR?
That's a nice idea, but with respect, I think it's naive. We tried reform, under the Cameron government. There was an attempt to renegotiate, and we came up with the Brighton Declaration under Ken Clarke. Didn't achieve much. There's been Rishi Sunak as Prime Minister going up to Helsinki, I think it was, and speaking to the Council of Europe, urging reform. Nothing came from that. So I think calls for reform of the convention are misguided and just another waste of time. I'll tell you why. There are 46 signatories. We couldn't even get agreement when we were members of the EU with 27 other countries. How on earth would we ever begin to get meaningful reform to what would be a contentious issue amongst 46 signatory countries? So I think it's impossible. And I think that we have talked about reform. We've danced around the issue of reform. We've tried it out for a decade. We've tried that reasonable, in quotes, approach. It has not worked. And the reason it's not worked is there's absolutely no political will amongst the other European countries to engage in that kind of process. So there might be lip service issue to the United Kingdom, but in reality, it won't lead anywhere. And so I'm afraid it's not a decision, it's not a position I've come to lightly, but it's on the back of harsh experience of being a lawyer, being Attorney General, working in the UK government, trying to control our borders. The only option really, if we want a clean and honest approach to our human rights system, is to leave the European Convention of Human Rights. It is, when I say that's not the end of the story, that is not, I think you say it's not a silver bullet. In itself, it's not the silver bullet, but it's shorthand for the beginning of a solution. We need to leave the courts, the jurisdiction of the European Court of Human Rights based in Strasbourg that is attached to that applies the European Convention. So we have to leave the convention. We need to scrap the Human Rights Act, which is our domestic legislation which incorporates or brings rights home, which is an exacerbating factor which makes this problem worse. We need to reform our judicial review arrangements because we've got a very expansive regime when it comes to administrative law, which again ties the hands of the government, undermining our ability to control our borders. We need to look at other international law. So there's a whole scope of work that needs to be done, and it needs to start with leaving the European Convention on Human Rights. Without that, everything else is meaningless.
On judicial review, I think there's a kind of it's certainly something I was struck by at the time, and I think it was while you were Attorney General, was that the Home Office came up with a policy of pushbacks in the Channel, and what happened was the union attached to Border Force took the government to judicial review. I think the Navy also said that they wouldn't carry out the policy. I think whatever you think of the policy of pushbacks, that to most people seems like a very strange situation where, an enforcement arm of the state is able to take the government to court for asking it to do something.
You can get a free bottle of Johnny Walker Black Label whiskey when you subscribe to The Spectator in our Black Friday sale. Go to spectator.co.uk/Friday24.
I agree. I mean, that's more a symptom of the broader problem, which is that we're vulnerable. We're vulnerable to an interventionist, politicised and expansionist supranational court, namely the European Court of Human Rights. And there's a whole body of jurisprudence, case law, that's emanated from that court, which influences our policy, which influences our lawmaking, and ultimately binds us and ties our hands. Pushbacks, let's take the issue of pushbacks, regardless of what you think about the merits of it. The Hersey Jammer case of a few years ago against Italy, that's the seminal case from the Court of Human Rights, which ruled against Italy and said that pushbacks are a violation of human rights. So actually, it would be very hard for us to legitimately do pushbacks on the Channel in light of that judgment. And there's a whole other plethora of international law that makes it difficult on the Channel. And the Channel's not the Mediterranean, I agree, but there are differences. So, we can't deport. The simple fact comes down. There are two main reasons why we need to leave the European Convention. Firstly, because of principle. It offends and undermines the cornerstone principle of our democracy, namely parliamentary supremacy. We've got a supranational court in the form of the Strasbourg Court, issues judgments, and no act of Parliament can disobey those judgments. And that's at odds with our culture of parliamentary supremacy. The operation of the court is, as I said, politicised and interventionist, such that it's now become a policy-making court, intervening and intruding upon the executive decision-making power of democratically elected governments. And we've seen that in a whole range of areas. So I think the principle of our membership of the court is at odds with these post-Brexit years, with the call for sovereignty and autonomy and to take back control of our laws. The second big reason is the practice of the court and the impact on our policy. So when it comes to migration and border control, it's the court's jurisprudence which has fatally undermined our ability to control our borders and stop the boats and return foreign paedophiles and terrorists and properly control our immigration policy. And some other policy areas are totally affected by the application of the European Convention.
It isn't just the ECHR. So when the Supreme Court ruled that Rwanda was unlawful, I think they said that that it also breached the UN Refugee Convention, the UN Convention Against Torture, the UN International Covenant on Civil and Political Rights. I mean, if you're talking about returning parliamentary sovereignty, there are a whole lot kind of more agreements that we're going to have to step outside of.
Yeah, that's why I say leaving the ECHR as a starting point. So
Right.
we'd have to legislate to limit some of the damaging effects of other customary international law and other international law contained, for example, in the Refugee Convention, some of the conventions you talk about. So it doesn't end with the European Convention of Human Rights, but that is the big starting point without which we won't make any progress. You talk about the Rwanda flights. The Rwanda saga provides a very good case study of, again, why we need to leave. At the beginning of that episode, the flights were originally grounded because of Rule 39 orders. Now, to me, they're an egregious example of Strasbourg overreach.
Can you just tell us what those are? Sorry.
Right. So what happened was previous Home Secretary, under Boris Johnson's premiership, we had the flights ready on the tarmac. And they'd made an agreement within their prerogative powers with Rwanda to remove illegal migrants from the UK to Rwanda. The passengers illegal migrants, people who had been identified for removal, were on the plane ready for removal. Some of these claimants, as you would expect, challenged the decision to remove. They went to the English courts, they went to the High Court, they went to the Court of Appeal, they went to the Supreme Court. All three levels of English judiciary ruled in favour of the UK government, deeming Rwanda to be safe, deeming it to be a proper and lawful exercise of government powers. They then, at the 11th hour, appealed the final decision to the European Court of Human Rights, and pursuant to an opaque process at which the UK government wasn't represented, a decision made by an unknown judge was made to block the flights. And the power that unknown judge used, or the legal basis that they used, was the Rule 39 order, so an interim order, an interlocutory relief or order to stop the flights pending, the broader and more detailed legal action. The problem with that, and many serious lawyers, former judges have come out expressing deep concern about the legitimacy of that decision, is that the Rule 39 order appears nowhere in the text of the European Convention of Human Rights. It's been a rule that's been made up by the court of its own accord. And that, to me, exemplifies the real problem of the expansionism that this court applies. It makes up rules as it goes along. No state has signed up to Rule 39 orders. No one has agreed to be subject to such a broad range of powers. And there's a serious legal debate about the binding nature of those Rule 39 orders. And many serious lawyers, Professor Richard Eakins, Jonathan Sumption, would say that they are not binding. So there was a real, that's a great example of the overreach of the court and the use of illegitimate powers to undermine a democratically elected government's authority.
So let's say the UK had decided, okay, we never signed up to this, to Rule 39. We're just going to ignore it, because we're not a signatory to it. What's the process then? What happens at that point?
Well, we didn't. So the UK government took the view that they were binding.
Yeah.
And that was really the fatal blow to the Rwanda policy, because then it was all kind of abruptly paused. We then had to go through legal action. The UK government won in the High Court on the merits. Rwanda was deemed to be safe by the first instance judge. That judgment was reversed at the Court of Appeal, and ultimately the Supreme Court ruled against the UK government, deeming Rwanda not to be safe. I disagree with that outcome, but that was the process. I believe that, interpretations of the European Convention of Human Rights via the jurisprudence of the Strasbourg Court operated in a way to stymie our ability to send people to Rwanda.
What do you make of the fact that Donald Trump has indicated that he might want to adopt the Rwanda policy?
I ultimately believe in the kind of value of the Rwanda policy. I think that it was the right policy. I think that it provides the necessary deterrent. It means that the people who come here are still treated humanely, because they are going to a country which will provide them with security, accommodation, livelihood, safety, and at the same time allowing us to deal with the influx of illegal migrants. So I think it is the right policy. It's a disappointment that the Labour government has scrapped it such a gung-ho way. And I'm not surprised that other countries are looking at it. I mean, I spoke to a lot of interior ministers when I was Home Secretary who were very interested in adopting a similar model. Italy's done something similar, but not quite the same. They are offshore. They're processing offshore in Albania, but the migrants could still come back to Albania. Interestingly, the European courts and human rights have blocked that policy at the moment. So they've been challenged in court on ECHR grounds. So the policy is actually on pause in Italy. Interesting development. But of course, I'm not surprised that someone like Donald Trump, who's taking a robust approach to border control,
would you advise him if he asked for your help?
Oh gosh, listen, I'm on the record as being someone who would have voted for Donald Trump had I had the chance. Maybe at odds with the Spectator
I don't know. We're a
Spectator
multiplicity of a multiplicity
editorial
of views.
team here. But listen, I think that I've been clear about my support from across the pond for Donald Trump. I think that he represents a new start, robust borders, a growing economy, and a robust stance on foreign policy.
How do you feel about? Recently in Westminster and kind of more broadly within the Conservative movement, if you can call it a movement, there have been kind of more discussions around things like fertility and connecting the fertility rates with immigration and saying, look, the reason we're bringing in all of these people is because we have a kind of sub replacement level, fertility rate. Do you think that things like mass immigration have an effect on the birth rate in this country?
I think that the UK has a worryingly low birth rate, and we are one of the worst countries in the world facing a crisis. Actually, South Korea has the worst birth rate in the world. I actually visited South Korea earlier this year to talk about this subject with them, and their government views it as a crisis, as an emergency. Mm-hmm. And I think ministers there are on the record of saying that South Korea may disappear because the population is not growing at a sufficient pace to support the ageing population. So they're literally not, countries with low birth rates are not producing the workforce and the taxpayers.
Which is exactly the same thing happening here.
We have an ageing population and a low birth rate. Those two things are true. Mass migration should not be the solution to a low birth rate because the costs of mass migration outweigh the benefits, to my mind. That's why I'm a strong advocate for lower overall migration, lower levels of work visas, a reduced number of foreign students, and controlling illegal migration. We have 9 million people on welfare, on out of work benefits in this country, costing us a record levels. And so I far prefer that we should be incentivising those who are claiming welfare or not working to their full capacity to actually be taking up these jobs first and foremost, rather than pulling the lever of cheap foreign labour.
Do you have a figure in your head of what you think is a sustainable rate of net migration into this country?
It's very hard to put a finger in the air and pluck out a number. But listen, in the 1990s, net migration was under 100,000. It was in the tens of thousands. Mm-hmm. So I'm going to use that hackneyed phrase. I support something in the low tens of thousands, definitely. We should be able to take a view with our newfound powers after our withdrawal from the European Union of where our economy has, unfulfilled needs in the labour market, and how those needs cannot be plugged through the domestic workforce. That needs a comprehensive assessment. We have the labour market assessment at the moment. I don't have much confidence in the way we assess the labour market at the moment. When I looked at it as Home Secretary, they were saying we had gaps in the hairdressing sector and in the HR sector that needed filling with foreign labour. Yep. I went back to them and said, sorry, but I respectfully disagree with that. So I think that we should be recruiting at home first and foremost, and only if all options have been exhausted should we be looking abroad. But I very much favour high-skilled, high-value people coming to this country who are going to contribute to our businesses, to the top of our professions. There's some talent that is based abroad, and I think encouraging that to come into the country is a good thing. So I'm not one of these people who just says pull up the drawbridge and no to everybody. I think we have to be much more discerning in our migration policy. At the moment, we are a free-for-all, and it's heavily weighted in favour of low-skilled, low-wage migration, which has a net cost to the economy rather than a net benefit.
Something that's connected to the immigration question is the riots that happened over the summer. You were Home Secretary. How do you think they were handled by the Labour government?
I do think there is a real problem with a two-tier approach with how the government comes from the top of government, and then how policing is carried out in this country. I think one standard is applied to one group and another standard is applied to another group. I don't think an equal standard is applied. And I think that was demonstrated with the riots. So I think that, a very quick response was presented by the police. They were proactively arresting those who were breaking the law, and that was a good thing. If people are breaking the law, everyone's got a right to protest.
Yeah.
But if they're breaking the law, if they're committing acts of vandalism, if they're harming others, then they're breaking the law and they should be arrested.
But there were some extremely harsh cases. So, like last week, there was the case of a care worker who I think got locked up for 9 months because she was live streaming the riots and said something deemed to be racist on the live stream. I mean, nine months in prison is that's a very serious thing to do to someone in their early 20s. What do you make of cases like that?
So I don't know the facts of that case,
Okay.
so I'm going to be shooting in the dark a little bit here. But I do think there has been, as I say, this perception, at least, of a two-tier approach. So not just in the response, so a quick response in response to these summer riots, but a quite slow response in relation to the pro-Palestinian protesters, for example. Many of whom were damaging property, who were being aggressive and harassing, who were chanting racist language or chants, who were scaling war memorials, who were firing flares, fireworks, wearing masks in prohibition of police orders. So, there's a clear case of breach of criminal law, but the police took a very different approach. They weren't proactively arresting. They were standing back, and their
Why
tactic...
do you think that is? Why do you think that is?
Well, this was my main gripe with the police at the time.
Yeah.
I would say to them, why aren't you arresting the people in real time? They were saying, well, we're not going to do that. We're going to adopt a different tactic. We're going to stand back and we're going to rely on CCTV footage after the event and calls for assistance, and we're going to arrest afterwards because we don't want to provoke a bigger riot if we go into a crowd and arrest. I disagreed with that. I thought that they should be arresting proactively because that would send the message that there would be a zero tolerance approach. They didn't want to do that, and I couldn't, within the limits of operational independence, I couldn't direct the police on the approach they took on the ground. So, but they took a very different approach with these riots. They did arrest proactively in real time, and they were very swift with the processing of some of the legal prosecutions, people turning up in court within days and receiving sentences within weeks. Very slow pace when it's come to the other kinds of riots. So I think that there has been a double standard. And I think, listen, when it comes to some of the sentences handed down, I think reasonable people would consider some of them to be harsh and disproportionate. But, those are judgments. I don't know all the facts, so I can't really go behind some of those judgments.
This is sort of connected to the non-crime hate incidents, which is something that have been discussed quite a lot this week after a Telegraph columnist was visited by the police. How does something like the non-crime hate incidents come about, and what did you make of them while you were in the Home Office?
Well, I wrote about this today in the Telegraph for your readers. Don't know if I'm sending them to a rival publication. But, the non-crime hate incidents have their genesis in the Macpherson report following the tragic murder of Stephen Lawrence. And there was an inquiry into racist incidents which might not meet the criminal threshold for a charge, but are nonetheless very concerning. And so they might help the police decipher a pattern of behaviour and therefore take preemptive action or even stop something worse happening. Over time, the concept expanded to cover all the protected characteristics contained in the Equality Act. And the threshold fell. So it's become dangerously low for a non-crime hate incident to be triggered. Namely, it's a subjective test. So if I get offended by your jacket, or if I get offended by something, let's not say your jacket, but if I get offended, I can report something to the police, and the police don't need any evidence. They don't need to really question whether my offence is unreasonable or unjustified. It's good enough that I'm offended, and that will trigger them to inquire and investigate. I think that's the fundamental flaw with non-crime hate incidents. The subjective test means that we're placing personal feelings of offence above objective facts, and they have expanded beyond recognition. I think thousands, I think hundreds of thousands of non-crime hate incidents have been recorded by the police in recent years. It's about 66 a day, and I don't think it can be right that the police are failing to investigate burglaries, something many people will be familiar with, and yet they're recording a record number of non-crime hate incidents.
Do you think kind of in their totality our hate crime laws in this country are too strict, are too severe?
I think there is a place for laws which make it clear that inciting violence, encouraging or celebrating or glorifying terrorism, all that kind of language shouldn't be lawful. But I do think expressing opinions which might challenge prevailing narratives, if you want to challenge the open borders kind of creed, if you want to express gender critical views, if you want to support Israel, those views shouldn't result in you getting a visit from the police.
Suella Braverman, thank you very much.